of the Manchester Police Department. Subsequently, the argument went that there was no damage, it's just chalk, wash it off. Subsequently, the Manchester Fire Department ends up coming, they use their water, wash it off, there's no outstanding or lengthy ongoing damage to the Manchester Police Department from that chalk. Defendants in that case, both Mr. Adam Muller as well as Mr. Wesley Gilreath, argued exactly the same as Mr. Staples does here today, that there's really no damage, it's just chalk, Judge, that does not violate the criminal mischief statute. And they also, similar to Mr. Staples, said, I've got a First Amendment right to do it, it's an important issue, I'm talking to the community or I'm addressing it to the police. In their case, I believe it was about police accountability or transparency. The cases I've handed you involve chalk on the exterior of the police department. Mr. Staples' case involves applying a sticker to the exterior of the Manchester Police Department. You can almost take the facts of this case, drop it into those two decisions from this court, leaving the holding exactly the same and to reach the same conclusion from our perspective. We're asking for a finding of guilty. I think this case is even stronger than the two that I've provided to Your Honor. In this sense, is that in those cases, the judge found that, or I should say this court, found that the application of children's sidewalk, non-toxic sidewalk chalk to the edifice and exterior of the Manchester Police Department was damage in the sense of the old statute, which talks just about damage. As I've given you the current statute as printed today or yesterday from the legislature, it's been broadened out beyond just your classic definition of damage, which
overbroad,
as Your Honor
I would say,
are traditional type, regular type cases that we see at a misdemeanor level in this court for damage would be somebody punched a window, the window has a big hole in it. Somebody slashed somebody's tires, they can no longer roll down the road because there's a flat tire. Husband and wife have a domestic dispute, husband breaks the cell phone, wife can now no longer use the cell phone. Those are under the classic mischief by permanent damage. Under the statute for which Mr. Staples is charged, and the allegation that he made a alteration or a defacement by application of the stickers is what violates the statute. So the legislature has changed the wording somewhat. I think from our perspective, the application of a sticker is clearly in violation of the statute that was in effect at the time. It does not need to destroy, it does not need to render the functionality of the object. It doesn't need to break the glass, it doesn't need to dent the door, it doesn't need to knock it off its hinges or anything of that nature to qualify as a mischief when you apply it to public property. It's the affixation of fixing the object, defacing in any way, as Mr. Staples sort of casually puts it, graffiti. It's the application of an unauthorized object that defaces the public property without authority. And again, both of those lengthy, in-depth decisions address both of the issues that Mr. Staples raises. One on the issue of damage, I suggest that the damage discussion is even stronger here than it was on that particular case. And two, a full analysis of any First Amendment concerns, both resulting in the conclusion that it was damage to put chalk on the police department, it was not protected First Amendment speech. We'd ask Your Honor, based on the testimony you heard from both officers, the evidence, including Mr. Staples' stipulation, which we appreciate that he agreed that he in fact did it, and viewing in a light that this court has already issued some in-depth opinions, we would respectfully ask the court to return a finding of guilty to this violation level mischief charge. Thank you, Your Honor.
I was previously aware of these cases. I'm glad you gave me an updated copy of the statute. Sir, you can have a brief minute for rebuttal if you wish. Go ahead, sir.
Yes, sir. So, I mean, just glancing over this case right here, it says that
Which one?
this is the 456/2001 CR 6808 554319. This is on November 15th. It starts off.
Yes, sir. Go ahead.
So you go down to paragraph 1, 2, 3, 4, 5, and it says that the appellate court wrote chalk is not a liquid and there is no evidence that the sidewalk was damaged. In this instance, there is evidence of pecuniary loss or damage because they called in the fire department to spray everything down, which was extra. So if the officer would have called in DPW to come and clean that off, that would have been pecuniary loss or damage. So where this case differs from these other cases is there is no pecuniary loss or damage. And damage has to be actual damage. If it's not defined in the statute, it has to be what the typical thing is for damage.
Hold on. One of the things that seems to be cleared up in these two cases, and especially with the new updated version of the statute, is we don't need damage. All we need is unauthorized alteration or tampering or defacement or whatever was on the face of the amended complaint.
And in that case, I will make the argument that this is void for vagueness and it is overbroad at this point because now they're encompassing the graffiti statute and trying to make it like, so what, now he tried to tell me he could charge me with both graffiti and this.
Well, he can charge you with both, but you can only be convicted of one.
Right, and so why would there be what makes it rise to the level of criminal mischief and damage if they're just turning this criminal mischief into a reiteration of the graffiti statute? It's overbroad and it's void for vagueness. It starts to encompass everything under the sun. Now, anything can be criminal mischief?
I don't think that's what the state is arguing, sir, but I understand you're alleging that the wording unauthorized alteration or defacement or tampering with, whichever ones the state is arguing, you're saying that's overbroad and it's vague, is that right?
And well, including whether they've added in, because all I have is criminal mischief. A person is guilty of criminal mischief who, having no right to do so, nor having any reasonable basis or belief for having such a right, purposely or recklessly damages the property of another. That was the original. And now it's been changed to include everything under the sun. Why? Why? Because of stickers. Because of stickers.
Sir, wait please. Back in May of 2021, the prosecutor amended the complaint to include the language made other unauthorized alterations to said property. Just as a matter
I didn't see that.
Hold on. Properly notifying you.
I never got notice of that. I never got notice of that. I never even had an arraignment for this case because it was all during COVID. Okay? I never received notice of this now that he's bringing out, oh, it's got all this vandalism, defacement, destruction.
Sir, hold on, please.
And I'm saying
Sir,
my authorization is the First Amendment.
Just hold on. I understand.
Okay.
That's why I'm giving this case the time that it deserves.
Appreciate it.
Can I make one comment?
Sure.
Just, not to the merits, you have just to the allegation that he wasn't aware or didn't have it. I didn't want that to be left as an unopened issue. Myself emailed with Mr. Staples. We have an ongoing, it's a good email address in the sense that we corresponded back and forth. I sent that amendment form to him on May 12th, the exact day that I drafted the amendment form. It was sent both in the body of the email. I explained that an amendment form was attached. I attached the amendment form, and Mr. Staples did in fact reply to that email. Basically, essentially, approximately 20 minutes after I sent it. So I do have a record. I just didn't want it. I don't think it's not critical to your analysis, but I didn't want Your Honor to think that I somehow slid that into the court record or something and did not take stuff.
Yeah, I didn't get it in the mail, so I probably didn't check the attachment. And if that's the case, then that's the case. You know,
right.
I don't know why I wouldn't get a copy in the mail.
You know, this is an interesting case. It's an important case. There's a lot of competing interests back and forth, whether it's the wording of the statute or whether it's the definition of damage or whether it's the definition of unauthorized alteration, and whether or not the First Amendment can be construed as a defense to damaging or altering property that is not your own. I appreciate the parties giving me all the evidence that I need. I appreciate the parties doing their closing arguments. Just to make sure that I get it right, first time out, I'm going to have to do a little bit of research, and I'm going to have to do a little bit of homework on this. So what I'll do is I'm going to take this under advisement. I know that's rather unusual, but that's what I think the best thing is to do for the court to make the best and most appropriate decision in this matter. I'll put together a written decision. I'll send it to the parties, and depending on what that written decision is, you know, we might have a plea in sentencing, or the case might just be dismissed, or what have you. But you'll get the court's thorough written decision in the mail. Okay? Is there anything else we can do for the parties today?
No, sir.
Thank you.
All right. Appreciate the parties being here, and